Why aren't states standing up to the president? Well, it might be because they are absolutely terrified of retribution. Take, for example, Maine. When the governor of Maine stood up to President Trump by having the temerity to suggest that Maine was going to follow the law, it did not go well. President Trump retaliated by cutting off funding for school lunches. But it might surprise you to learn that such tactics are legally dubious. Liz Dye has more because I just can't even.
Thanks, Devin. We often joke on this channel about Donald Trump being like a schoolyard bully who knocks down kids and steals their lunch money. But this time, it's actually true. President Trump is big mad at the state of Maine, and so he's grabbing the kids' lunch money literally. The fisticuffs started on February 21 when the nation's governor showed up at the White House for an airing of grievances. It was a wide-ranging speech.
We just had the highest poll numbers I've ever had. It's just so terrible. I see pictures that you fortunately don't get to see. Even the Democrats are amazing people. FEMA was a disaster. FEMA wasn't there. We've done it the other way. And we're working with a very nice person. You fix it. You take care of it. I'd rather have you do it. You'll save a lot of money. You have a little bit of skin in the game, but energy caused our problem.
And all that was just in the first 15 minutes. 30 minutes later, he was still rolling, fantasizing about two transition people that were fighting in the women's boxing in the Olympics. That was apparently a reference to Algerian boxer Imani Khalif and Taiwanese boxer Yulin Ting, neither of whom is trans. Both these athletes were born and raised as girls. And the fact that there's been rampant speculation that they have some kind of hormonal or chromosomal advantage pretty substantially undercuts the claim that there are only two genders and everyone can tell the difference, which is something to keep in mind in about 15 minutes when we get to the part where the US government doxes high school students it thinks are trans. Because these guys think everything is drag queen brunch, only not fun. Back at that lunch with the governors, lying about the boxers reminded Trump how much he hates trans kids getting to play pickleball and badminton, and so he decided to yell at the governor of Maine, Janet Mills.
Are you not going to comply with it?
I'm complying with state and federal laws.
Well, we are the federal law. Well, you better do it. You better do it because you're not going to get any federal funding at all if you don't.
Did you catch that part where Trump promised to ensure that no federal money would go to Maine until the state started enforcing his executive orders barring trans kids from playing sports? Well, he meant it. But as it turns out, when he said, "We are the law," the president was confused, if you can even believe it. On his very first day in office, Trump signed an executive order defending women from gender ideology extremism and restoring biological truth to the federal government. Essentially, he declared that trans people don't exist and accused ideologues who deny the biological reality of sex of using legal and other socially coercive means to permit men to self-identify as women and gain access to intimate single-sex spaces and activities designed for women. He said that female means a person belonging at conception to the sex that produces the large reproductive cell, and male means a person belonging at conception to the sex that produces the small reproductive cell, which is wildly unscientific. For one thing, cisgender boys don't make any reproductive cells, big or small, until puberty. But Trump instructed his attorney general to treat these definitions as law for all government purposes, including enforcement of the 1964 Civil Rights Act. That's the landmark civil rights statute that bars discrimination on the basis of race, color, religion, national origin, and sex. The act protects Americans from discrimination in voting, housing, education, employment, and public commerce. And the Supreme Court ruled in a 2019 case called Bostock v. Clayton County that discriminating against gay and trans people at work counts as illegal discrimination on the basis of sex for the purposes of Title VII of the Civil Rights Act. That decision was actually authored by conservative Trump appointee Justice Neil Gorsuch and joined by Chief Justice John Roberts. Then in 2021, the Supreme Court declined to hear the appeal of a Fourth Circuit ruling that said forcing a trans boy to use the girls' bathroom was discrimination on the basis of sex under Title IX. In 2023, the Fourth Circuit struck down West Virginia's ban on trans kids playing sports and let a little girl named Becky run track with her schoolmates. So far, the Supreme Court has not granted cert on that appeal. But the court has been tepid on extending the on the basis of sex ban to the educational and health contexts. For instance, it allowed bans on gender-affirming care for trans kids to go into effect in Tennessee. That case has not yet been decided, but during oral argument, Chief Justice Roberts said the Constitution leaves the question of whether trans medical care is safe to the people's representatives rather than to 9 people, none of whom is a doctor. He meant the justices. It's safe to say that the law is kind of in flux right now on LGBTQ+ issues, and it's not at all clear whether the Supreme Court would uphold the right of trans kids to play sports. But that's not what President Trump is demanding. He's not saying that the state should have the right to ban trans athletes from competing on the team that corresponds to their gender identity. He's saying that Title IX requires states to ban trans athletes from playing. So on February 5th, he put out a second executive order, quote, keeping men out of women's sports, purporting to ban trans kids from playing sports as a matter of safety, fairness, dignity, and truth. And he instructed the Department of Education to yank all education funds from schools that just let the kids play. And he instructed the Attorney General to bring enforcement actions against states and institutions that refuse to comply. So when Governor Mills said, I'm complying with state and federal laws, and Trump got mad and said, we are the federal law, that's what he meant. He meant he'd signed an executive order that said letting trans kids play violates the 1964 Civil Rights Act, and he'd unilaterally declared that allowing trans kids to play sports discriminates against girls. But that did not make it law. The president doesn't make law. That's Congress's job, and he doesn't get to interpret the law. That's the responsibility of the courts, which was, of course, exactly where the dispute was headed. Trump's revenge tour started almost immediately. The very next day, the U.S. Department of Education's Office for Civil Rights announced that it was investigating Maine's Department of Education for violating the civil rights of female students. The letter said that allowing trans girls to play sports deprives girls and young women of equal athletic opportunities in violation of Title IX. Again, no court in the land has ever said that. And it pointed to Trump's executive order stating that it is the policy of the United States to rescind all funds from educational programs that deprive women and girls of fair athletic opportunities. Also that day, the Office of Civil Rights at the Department of Health and Human Services announced that it too was initiating a compliance review of the Maine Department of Education based on reports that the state was allowing transgender athletes to compete in women's sports in violation of President Trump's executive order. On February 25th, Attorney General Pam Bondi sent her own nastygram to Governor Mills saying, let me be clear, requiring girls to compete against boys in sports and athletic events violates Title IX of the Educational Amendments Act of 1972. This letter is weird. It's weird for the Attorney General to be sending out letters yelling at governors. It's weird that it just waves in the direction of the Constitution and Title IX without citing a single case or statute or federal regulation that supports the proposition that Title IX requires the exclusion of trans athletes, probably because there aren't any supporting statutes. And most of all, it's weird because it just says, now the law means the opposite of what it used to mean, so do what we tell you or else.
Respect my authority!
Investigations usually take months, but hey, wouldn't you know, the Department of Education and the Department of Health and Human Services were both able to conclude in less than 4 weeks that Maine was violating Title IX. But the first federal agency to hit Maine was the Social Security Administration, where Acting Administrator Leland Dudick cut off the ability of Mainers to report births and deaths at hospitals and funeral homes rather than going to a Social Security office. He was told that terminating the contract would result in improper payments and potential for identity theft, and he said it would be worth it because while our improper payments will go up and fraudsters may compromise identities, no money will go from the public trust to a petulant child, by which he meant Governor Mills. After major public pushback, Dudick reversed himself, telling the New York Times, I was ticked at the governor of Maine for not being real cordial to the president. I'll admit I screwed up. But the first agency to really hit Maine was the Department of Agriculture, which administers school lunches.
Sorry to interrupt, but if you're going around stealing children's lunch money, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
On April 2nd, Secretary of Agriculture Brooke Rollins sent Governor Mills yet another nasty letter. She said, you cannot openly violate federal law against discrimination in education and expect federal funding to continue unabated. Your defiance of federal law has cost your state, which is bound by Title IX in educational programming. Rollins is a lawyer with an admittedly impressive resume, but she clearly understands that this job requires her to say very silly things on camera.
What you have assembled in your vision is a turning point and an inflection point in American history. And so just being a part of that is the greatest honors.
Rollins said she was freezing federal funds for certain administrative and technological functions in schools. And she threatened to cut more if Maine refused to comply with Trump's executive order. She said, this is only the beginning, that you are free to end it at any time by protecting women and girls. The letter also promised to review all of Maine's federal grant awards to root out funds that support a leftist socialist agenda, by which she meant feeding kids. Because although the letter promised that if a child was fed today, they will be fed tomorrow, the administrative and technological function she cut first was school lunch money. The very next day, the state was cut off from accessing funds for the Child Nutrition Program, CNP, which is administered by Maine's Department of Education. CNP administers the National School Lunch Program and the School Breakfast Program. It also feeds vulnerable adults in adult daycare programs. CNP could still access the funds for direct food purchases, but it couldn't get any of the money earmarked to pay the lunch ladies or for equipment or to administer the program or to support local farmers who work to supply Maine's children with healthy local food. Because the way to protect female athletes is to take away their lunch. The state of Maine filed suit a week later. Now, this lawsuit is not about Title IX, although it does point out that several federal courts have held that Title IX and the Equal Protection Clause require schools to permit transgender girls and women to play on girls' and women's sports teams. And it is not about the legality of the president stripping away unrelated federal money as a means of forcing states to do stuff, although the Supreme Court ruled in 2012 that the Obama administration could not withhold Medicaid funds as a means to force red states to expand Medicaid to ensure more poor people. It is about whether the president can arbitrarily withhold congressionally allocated funds without going through all the steps laid out in the statute. And the vehicle for that kind of a legal challenge is the Administrative Procedures Act. Under the APA, you can challenge something the government does if it's arbitrary and capricious. Here, Brooke Rollins just cut off the school lunch money from one day to the next. And as Maine points out in its lawsuit, there's a whole process to withdraw funds from federal grantees who don't comply with the terms of their grants. The secretary has to investigate and make findings and limit the cuts to specific programs that are not in compliance. She can't just say, I'm going to keep cutting agriculture funds at random until you change your school athletic policy, like she did in that pissy letter. And under federal statute and regulations, she had to tell Congress in advance what she was doing and why, which is another step she just skipped. The state moved for a temporary restraining order, and they got it. Judge John Woodcock, a George W. Bush appointee, wrote a 70-page ruling laying out all the ways kids in Maine will go hungry if the Trump administration cuts off CNP money. He said, absent a TRO, the funds that pay for the 12 CNP employees who monitor the National School Lunch Program and School Breakfast Program and process the reimbursements to schools are inaccessible. Without these funds, there will be no CNP staff to collect, approve, and process claims for reimbursement for schools and other facilities providing meals to children and vulnerable adults. In other words, there will be no way to get funds from the USDA to the schools and other facilities, and children will not be fed. Judge Woodcock ordered the Department of Agriculture to give Maine its lunch money and stop cutting off funds without complying with legally required procedure. Judge Woodcock also did something sort of funny, which was to impose a bond. Basically, if you lose a civil case, the other guy can start collecting damages right away, even if you appeal. And that makes sense, right? Because otherwise you, as the losing party, could just drag out appeals for years on end and then say at the end, like, oh, sorry, I spent all the money, nothing left for you. But if you're the one appealing, you can post a bond, which is basically handing the damages award over to the court to hold during the appeal. Trump himself had to pay enormous bonds in the defamation and civil fraud suits he lost when he was out of office. But that gave him a bright idea. What if courts forced people who sue the government to post a bond? Now, Rule 65C of the Federal Rules of Civil Procedure does say that a court should impose a bond on the party that gets an injunction to cover the cost to the other guy if the injunction is later deemed to have been wrongly issued. But the rule leaves the amount up to the judge, and most of the time the amount is zero. Because judges understand that if you require bond in every circumstance, it would make it effectively impossible for poor people to get injunctive relief, right? The county could say, we're going to bulldoze your house tomorrow to build the interstate. And unless you could post a bond to cover the cost of diverting the interstate to go around your house, you'd have no ability to stop it, which is more or less what Donald Trump wants to happen. So the president put out an executive order saying that the Department of Justice should demand that parties seeking injunctions against the federal government cover the costs and damages incurred if the government is ultimately found to have been wrongfully enjoined or restrained. So on top of all the other embarrassing arguments the Justice Department lawyers are having to make these days, they're also having to ask federal judges to impose bond in the 11D7 cases where the administration has had a restraining order slapped on it. So here, they had to ask Judge Woodcock to make Maine post bond to give up for the grievous harm inflicted on the federal government if it had to hand the state the roughly $3 million allocated by Congress to feed poor children. Judge Woodcock thought about that one, and he decided he would impose a bond of $1,000, or roughly 0.0003%. Now, in most of the cases where the Trump administration got hit with an injunction, the Justice Department appealed immediately. But that's not what happened here. Instead, the state attorney general and the Justice Department jointly agreed that they would ask Judge Woodcock to leave the TRO in place. And I think it's not hard to see why. Because in its lawsuit, Maine pointed to all the times the Trump administration threatened to pull federal funding from the state because it supposedly violated Title IX by letting trans kids do normal kid stuff. But the one thing the Justice Department didn't do was file a federal enforcement action to test that spiffy new interpretation of Title IX in court, which was kind of a glaring omission. Like, if you really thought the courts would say that Title IX requires states to discriminate against trans kids, you'd file a lawsuit instead of trying to wield federal tax dollars to bully states into doing what you want. And so, to fill this glaring hole, the Justice Department did file a lawsuit of sorts. On April 16th, the Trump administration sued the Maine Department of Education. The complaint says, by prioritizing gender identity over biological reality, Maine's policies deprive girl athletes of fair competition, deny them equal athletic opportunities, and expose them to heightened risk of physical injury and psychological harm. The government says it violates Title IX to let trans girls play sports because undeniable physiological differences between males and females provide boys with inherent advantages in strength, speed, and physicality that predetermine the outcome of athletic contests, which manages to be both biologically and statistically illiterate. I mean, by that logic, any boy could beat any girl at any sport, which is clearly not correct. I mean, Billie Jean King's famous tennis match against Bobby Rigg, the so-called Battle of the Sexes, was more than 50 years ago. King, who was a pioneer for women's equality in sports, cleaned Rigg's clock, and she's been a strong advocate for trans athletes since then. Yes, I do know that there are plenty of weekend warriors who really honestly believe that they could beat a WNBA player, but that's not actual legal evidence, and it's definitely wrong.
Griner and BG gets her second dunk of the season.
The lawsuit cites zero case law to back up the claim that allowing trans athletes to play counts as gender discrimination under Title IX, because, again, there isn't any. Instead, it points to the non-discrimination mandate in the statute and to Trump's executive orders and says, now this law means what we say it means, which would be true if this were a monarchy. But since America is a democracy, Congress passes laws and courts interpret them. And since we're talking about the structure of American government, if Congress doesn't pass a law, the states get to make their own. Like Maine, which passed a human rights law in 2021 that protects the right of trans kids to play sports. But that's not the only thing the DOJ is confused about in this complaint. See here where they say federal regulations require that if an educational program separates teams by sex, the teams that the program designates as female teams must be completely separated by sex? Let's check out 34 CFR section 10641B, shall we? The first part says a recipient of federal education dollars can sponsor co-ed sports teams. Okay, cool. And the second part says where the recipient of federal education funds operates a team for members of one sex, but operates no such team for members of the other sex, and athletic opportunities for members of that sex have previously been limited, members of the excluded sex must be allowed to try out for the team offered unless the sport involved is a contact sport. So if there's no girls' soccer team, you have to let girls try out for the boys' team. And if there's no boys' field hockey, you have to let boys try out for the girls' team, which kind of seems like it means the exact opposite of what the DOJ is suggesting. The complaint goes on to talk about 3 high school athletes whom the government identifies as trans. We're not going to show you that part of the complaint because it doxes children, and we're not assholes. Also, Donald Trump thinks every female athlete who doesn't look like a swimsuit model is trans, so big grain of salt there. Let's just say the government is big mad that some kid won a pole vault contest and another kid came in 3rd place in a skiing competition and a 3rd kid is playing basketball, and I don't know if she's a starter or if she plays left bench, but I hope she's living her best life and the adults around her behave better than this. Okay, just a few more words on this goofy lawsuit, which aims not only to make Maine be mean to trans kids, but seeks money damages for the supposed harm to the government from allowing some poor 8th grader to run track with her classmates. The Justice Department says that before Maine passed its human rights law, 56 trans athletes participated in sports in Maine between 2013 and 2021. It's not clear if that's 56 different kids or like a dozen kids over 7 years having to get a waiver signed every time they signed up for fall field hockey or spring lacrosse or whatever. The source material says that of those kids, there were only 4 trans girls. So obviously, this is not a big problem. Governor Mills says we're talking about a grand total of 2 kids for the entire state right now. And so, to prove that this is too a thing, the Justice Department says that approximately 2,374 Maine high schoolers, or approximately 4.5%, identified as something other than their sex, and cites this as proof that boy athletes must be competing against girls in sports designated for girls. I mean, if you really believed that statistic, you'd be advocating to exclude 1 out of every 20 kids from participating in sports, which would be truly vile and cruel. But since we're talking about people who want to take away kids' lunches, I guess that tracks.
Thanks, Liz. Now, if you live in Maine, you probably don't want the Trump administration to see your IP address. You actually might want to set it to a different state, which is good advice no matter what state you live in, which is where today's sponsor, NordVPN, comes in. Because you know that incognito mode isn't actually incognito, right? Well, with Nord's VPN no logs policy, your internet service provider doesn't get to snoop on what you're searching, and neither does NordVPN. I especially like to use Nord when I'm using unfamiliar networks like the free Wi-Fi at cafes and airports. And Nord is more than just a VPN. It comes with a whole suite of threat protection tools. For example, if you follow some of your favorite creators on social media, you might have heard the stories of a channel getting hacked, basically a creator losing access after a successful attack or leaked password. This happens way too often. And NordVPN's threat protection includes specific features to warn you about phishing links, as well as features like a blocker for malicious ads and dark web monitoring to alert you if your passwords have been leaked. And of course, NordVPN is a great VPN. With Nord, you can surf the web anonymously, and your location stays private. It allows me to set my location all over the world, which lets me access the different versions of my favorite websites. And when I'm out of the country and try to connect to my Gmail or a bunch of other things that I'm logged into, all of these accounts would usually freak out and tell me that I'm being hacked. So now I just reroute my connection to the United States, and my Gmail and everything else is happy. And not only is Nord the fastest VPN on the planet, but you get 24/7 customer support to help you whenever you need it, and a 30-day money-back guarantee for all users. So if you'd like to give NordVPN a try, click on the link that's on screen now or down in the description. Every purchase of the 2-year plan will receive 4 bonus months on top, and it's completely risk-free with Nord's 30-day money-back guarantee. So click on the link below to get 4 months free and a huge discount with NordVPN, and of course their risk-free 30-day money-back guarantee. And after that, click on this box over here for more LegalEagle, or I'll see you in court.